gonna do it. I'm gonna do it. This is how we start every stream. Hi everybody, it's me, AV. Welcome back to another Power Hour. Breaking news: Karen Reed is suing everybody. Karen Reed said, "Watch out! I'm not playing with y'all anymore. Watch out! I'm coming for your neck." And we are diving into that lawsuit. Today is Tuesday, November 18th, and we are going to read this lovely 46-page document. Now, so many people are covering it. Everybody and their mama is covering it. So I'm just going to read through it real quick, give you guys my perspective, my legal perspective, and we will go from there. Shout out to everybody that's coming in the chat. Couple reminders, do me a huge favor, hit the like button as you are on your way in. This dropped this morning, was filed yesterday afternoon at about 3 o'clock. Couple channel announcements. We're going to go live again on Thursday on the Courtney Clenny thing. We were just live this past Sunday, so that was fantastic. Really looking forward to diving into this document as well. December is shaping up to be very busy with a lot of cases that we're covering, as well as January. So we're here. I've got my Too Cute by Half shirt on, right? And we're going to jump back into it. Honestly, I haven't been wanting to touch the Karen Reed case. My day ones know why, but we are doing it today. Also, just really want to get my mind off of stuff. I don't know if you guys have heard about what's going on in LawTube this week, but Nate, the lawyer, one of the only Black attorneys on this platform and a personal friend of me and the lead attorney, he had been diagnosed with a brain tumor. So he's going through surgery right now. Everybody in the LawTube community, we're all cheering him on and we're praying for him and his family right now. So a little bit of a somber thing, but you know, this week, every stream that I do, I am starting off with prayers up for Nate the lawyer, just because he means a lot to me. He's one of the only people that really gave me a shot on this platform as somebody to collab with. So I hope he is doing well. We are all praying for him, and we hope that he is going to pull through. So as soon as I know anything, I will let you guys know. So still, you know, keep your notifications on, all of that stuff. And we're going to make sure that Nate is good. But this news about Nate had been shared Saturday, and it's not like, you know, people are making rumors up about him. He personally shared this news on his channel and with his community. And again, he's done a lot for me personally. He's done a lot for Lead. So, you know, we are starting every single stream this week with prayers for Nate the lawyer. Okay, chat, are y'all ready to get into this debauchery? It's going to be the news of the day. Everybody and their mama is covering it, but we are going to look at it, at least, you know, shed some light from my perspective, right? So let's take a look. And I know I've got some Cash Apps that already came in, Super Chats that came in as well. I will read those towards the end of the stream. I really want to dive into this one because I want to see what Karen's team has said here. And before we dive into it, Karen's team has actually put out a formal statement. This came from Ted Daniel a few minutes ago, I think about an hour ago. So why don't we start with the statement and go from there. So let me stop sharing for 1 second. Actually, I'll just read it to y'all. This is the statement. So we have statements from both sides. We have statements from Karen Reed's team, and then we have statements from the attorneys from Brian Higgins, Nicole Albert, Brian Albert, Jen McCabe, and Matt McCabe. So let's start with, and I am going to have to show it to y'all. Let's start with that. So let's stop sharing for a second. Share screen. Let's go over to good old Ted on Twitter. All right. So let's start with this statement from Alan Jackson and Karen Reed's civil team, okay? It says, today's filing speaks for itself. It is a meticulously documented civil action grounded in evidence, law, and the Constitution. For more than 3 years, Karen Reed was dragged through a baseless criminal prosecution engineered by individuals who abused their authority, manipulated the investigative process, and trampled her rights. Our complaint lays out in stark detail the meticulous prosecution, the conspiracy, the civil rights violations, and the intentional misconduct that these defendants visited upon an innocent woman. If these defendants want to answer for that under oath, we welcome it. AJ said, let's go. AJ said, come on, let's go. We welcome it. Okay? We welcome it. Let me make myself smaller so y'all can follow along. What we will not do is legitimize a threat to file some imaginary defamation case. Oh, get him, AJ. That threat is nothing more than a desperate attempt by those defendants to distract the public from the very real legal jeopardy they now face. When people start waving around defamation claims, oh shit, to mask their own legal troubles, it tells you everything you need to know. They don't want sunlight. They want silence. Karen Read spent years fighting for her freedom against a corrupted investigation. Now she is fighting for accountability. And unlike the criminal case, this time the defendants don't get to hide behind badges, back channel favors, or manufactured narratives. They will have to answer in the court of law for every lie, every omission, every manipulated report, and every constitutional violation they committed. Karen Read is not backing down. Our team is not backing down. Accountability is coming, and these defendants can threaten all the phantom lawsuits they want. But the truth does not flinch. Y'all give it up for AJ. I mean, give this such a great writer. It's beautifully written. Oh, AJ, that was great. One more time for AJ. Okay, one more time. Wow. Look at that. All right. So that right there, chat, that is the response from Karen Read's team after this has hit the news this morning. Okay. Now we are going to scroll up and see what the Canton 8, is that what people are calling them now? The Canton 8? What the response is from the defendants in this lawsuit. Now, this is not a surprise because we knew it was coming. Karen Read had a hearing about a month ago. A few of us have watched it here. And in that hearing, she was getting ready for the civil side of the lawsuit from the O'Keefe family, right? And, you know, that was against Karen and the bars. The judge in that case said, hey, if you want to countersue everybody, it's going to be a longer process. So it might make sense to separate everything, right? If you separate everything, we'll be ready to go to trial as early as March. So that was the last conversation with the judge. Now, this past Friday, the case, that civil case had been transferred to a different judge, right? So that judge is no longer on the case. It's a new one. Now, a lot of people haven't been talking about that. I was actually really surprised that there wasn't more chatter about this over the weekend, but that case has now been assigned to a different judge. So for me, when I'm seeing all this come out, I'm like, oh, well, now this makes sense. Karen's team is actually doing what the judge had instructed. And in exchange, you see that that civil case generated by the O'Keefe family is moving through the process. And that actually could start. I mean, now that she's separating everything, it could start a little bit earlier. Now, here's the other thing. Yesterday, the defendants, because we're about to read their statement, the defendants were talking about how they were going to sue Karen Read, that they were going to initiate a lawsuit against her. Now, they publicly said that yesterday. You know what Karen's team did? They didn't say anything. They didn't say anything at all. AJ was like, that was too cute. It was too cute by half, okay? That was cute. But we're going to kill y'all in the morning. Like, not literally, but meaning we're going to hit you with a lawsuit in the morning. And that's exactly what happened. So now that that has happened, thank you so much, Nurse Janice. That judge has retired. That was the reason why I think he had known that. Not Bev, not Bev. This is the gentleman. He was he seemed younger to me. that was assigned to the civil case that the O'Keefe family generated has retired. And that was the reason why that civil case has been reassigned to another judge. All right. Now, let's look at what the other side says here. All right. So that's Karen's statement. So Ted reached out and he has a statement from the attorneys for Brian Higgins, Nicole Albert, Brian Albert, Jen McCabe, and Matt McCabe. It says, the allegations made by Karen Reed are entirely false, defamatory, and without merit. Our clients categorically deny each and every claim. This lawsuit is nothing more than a continuation of baseless conspiracy, nothing more than a baseless conspiracy narrative that has caused significant harm to the reputations and lives of innocent people. Our clients acted responsibly, fulfilling their civil duty as witnesses, and have participated appropriately in the legal process from the outset. Ms. Reed's claims distort the facts, they misrepresent the evidence, and target private citizens in an attempt to deflect blame. As reported yesterday, we will hold Ms. Reed accountable for the harm she has inflicted and the conspiracy she and Aiden Carney, also known as Turtle Boy, have manufactured. So that's the end of the quote. It is interesting. I want to now read it. And see what is in Karen's lawsuit, because it's a long time coming, but you've heard that very fiery statement from Karen's team. Like, we're not backing down. These people, they did a lot of things that breached her rights, right? So let's take a peek at it. Now it is time. We're going to stop screen sharing and let's pull up that PDF because I can't wait, chat. I really can't. Here we go. Here it is. Are we ready? Let's go in. Let's see what's all the tea is about. But here we go. I'm going to make myself small so that way you guys can follow along with me. All right. So this was filed yesterday, November 17th. I think the timestamp right up top is around 3:14 p.m. All right. So we can see that this was yesterday afternoon as far as a filing filed in Bristol County. Okay. This is Karen Reed, the plaintiff. She's going up against Proctor. Okay. She's going up against Buchanan. She's looking at Tully. She's looking at Brian Albert, right? Nicole Albert, Jen McCabe, Matt McCabe, and Brian Higgins. Higgy, all right? Now let's read it. Okay. For 3.5 years, plaintiff Karen Reed was wrongfully accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police and those working in tandem with the Massachusetts State Police to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe. Now, you know what's interesting, chat, that I just noticed? Look at all the people up here. You know who's missing or what is missing from this group as an entity from the defendant pool? The Massachusetts State Police. Now, when she was doing that whole countersuit during that hearing last month, she included the Massachusetts State Police, but now she's coming after these people individually. So that's new. All right, let's keep going. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who objectively failed to ensure that justice was sought and served in the aftermath of January 29, 2022. All right, so that's the first thing. Next, Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in the defendants, Brian and Nicole Albert's home. They said in the home. Oh, Karen said, watch out. In the home. in an altercation. Oh, that's new. Well, not new. We knew it, but she's actually saying it. During a late night house party with other defendants, collectively known as the House Defendants. Oh, we're calling them the House Defendants now, Chad. Like they are the House Defendants. Okay, these people are the House Defendants. I love this already. We are on, for everybody coming in, hit the like button, share it out to more people. We're only on paragraph 2. And already we have them known as the House Defendants. After a night of heavy drinking, the House Defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House Defendants conducted a Google search for information about what? Y'all know, House Long to Die in the Cold. Wow. Moved Mr. O'Keefe's body outside, placed him on the Albert's front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle. Then he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Albert's lawn until Karen Reed found him later that morning. From the beginning, investigators from the Massachusetts State Police allowed the House Defendants to direct the investigation away from themselves and towards Miss Reed. The House Defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. The lead investigator, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House Defendant. Now they go individual. It's the House Defendants, but each one of them is going to be known as a House Defendant, right? Brian Albert was a longtime Boston Police Department officer, and House Defendant Brian Higgins was an agent with the ATF. Number 4, adhering to the unwritten rule of protecting their own, Proctor and his Massachusetts colleagues intentionally disregarded the obvious and compelling evidence tying the House Defendants to O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face, a deep gash in the back of his head, suggesting that he was punched and fell backwards, hitting his head on a ridged surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. See, this is important. They're saying this stuff in this document. Not a single injury. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. Interesting. And real quick, guys, I know we have a lot of colleagues that are reading this document. I said this at the beginning. Everybody and their mama is reading it. Melanie, so much love for Melanie. I did see her live reading this. Nick Starro, I saw him live reading this. Everybody's reading it. It is the hot news of the day. And the great thing is that you have so many different perspectives where everybody wants a take from their favorite YouTubers, and we all understand that, right? So much love to Melanie and the cupcakes. We love her over here. Let's keep going. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the house, Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this because he's a Boston cop. And when they said that, they clarified that they meant Brian Albert is a Boston cop, and that Proctor was determined to make the investigation cut and dry, bringing charges against the girl. Indeed, Proctor made his intentions clear in writing, Karen Reed had zero chance of skating. She's fucked. This pronouncement was a mere 16 hours after O'Keefe's body was discovered on the Albert's lawn, and Proctor had not even walked into the house. True to his promise, Proctor and his colleagues did not search the house for blood evidence, right? This is why everybody was like so surprised by this case. Like, why didn't you go inside? You didn't look for blood evidence inside. You didn't look for any evidence inside. You just questioned people. That's a little strange. Resulting from the gash to the back of the neck of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without a hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the Massachusetts State Police, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Albert's German Shepherd that was in that house on January 29th, a dog that had a history of attacking other dogs and people. Neither Proctor nor any of the Massachusetts state troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on hands, knuckles, or face, or bruises on their bodies. They did not seize or search the House defendants' phones, or even bruises on their bodies. They did not seize or search the House defendants' phones. They conducted only unrecorded conversations with Proctor's friends. Proctor's friends and acquaintances without any attempts to corroborate their stories. He called them Proctor's friends and acquaintances. Interesting. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Ms. Reed as implicitly directed by the House defendants through the misrepresentations they made to the police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. That's right. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device, and used his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential info about the investigation to his sister, who passed that information to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information to the rest of her family and the House defendants. Part of the communication included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants, singularly focusing on Ms. Reed. Proctor then went so far as to manufacture evidence to ensure that Ms. Reed, not his friends and fellow law enforcement officers, was blamed for John's death. This included planting evidence at the scene, on Mr. O'Keefe's clothes, and on wow, they're literally saying it. This included planting evidence at the scene, on the clothes, on her vehicle, to support the false narrative that Miss Reed hit John with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered exposed the corruption and bias at the core of the MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor said that Miss Reed was a whack job, see you next Tuesday, retarded, a nutbag, and a babe with no ass. Proctor further ridiculed and derided Miss Reed for her serious medical condition, stating that her balloon knot leaked poo. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting the search of Miss Reed's phone, he was looking for naked pictures of Miss Reed. Disappointed, he reported that there were no nudes so far. Disappointed, he reported. That was actually funny. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully, she kills herself. Indeed, Proctor's supervisors and the MSP knew about and condemned Proctor's unlawful conduct, and in some instances expressly encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Buchanan, responded with a thumbs up emoji to a text calling Miss Reed retarded. Oh, Yuri, I forgot you did that, Yuri. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret to his bias against Miss Reed, demonstrating a clear prejudice against her from the outset. Relying on the manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing towards the House defendants, the Commonwealth secured 2 separate arrest warrants for Miss Reed and knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underlie plaintiff's meritless wrongful death claim against Miss Reed, but they also form the foundation for Miss Reed's claims against the defendants. These acts violated Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. On June 18, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory in part because the overwhelming physical, scientific, and medical evidence established that Miss Reed's vehicle did not strike Mr. O'Keefe, and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Miss Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every Massachusetts state police officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Miss Reed. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Jeff Noble, stated, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as the head of it, the state police has and will continue to improve in these regards." In an interview with the Boston Herald, Noble acknowledged the systematic nature of the police's conduct in Karen's case. "I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor. These hollow words do nothing to right the devastating wrongs that have been visited on Miss Reed." Noble's words confess a sickness deep in the marrow of the MSP, not a sickness, but offer no remedy, no medicine, no relief to someone who so brutally victimized by it. On March 19th, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the trial board found Michael Proctor guilty, that's in caps, of a Class A violation, which included that he was biased in his dealings with a homicide suspect or bought otherwise on himself and the Massachusetts State Police into disrepute. Miss Reed's life was not merely turned upside down by the Massachusetts State Police and the House defendants' misconduct. It was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against Massachusetts State Police, Proctor, his supervisors, the town of Canton, and the House defendants, Miss Reed seeks, at minimum, to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Wow, Chad. I mean, that's a great start. It is a great start. So whoever is writing this or the team that worked together to write this, they did a great job. Let's keep going. So here are the parties. So you have Karen, who is the plaintiff. Let's talk about the defendants. So we're going to go to Proctor, right? He lives in Canton still. He is being sued in his personal capacity, not as a police officer for the state police. You have Buchanan. He is a state police officer. He lives in Stoughton. He is being sued in his personal capacity as well. Tully as well. He's in Hingham. He's being sued in his personal capacity. Looks like the Alberts have moved. Brian and Nicole are now in Norwood. They're in Norwood, Massachusetts now, right? The McCabes are still in Canton, it looks like. So Jen and Matt. And Higgins is in Sandwich. All right, so he's down south. Jurisdiction and venue. So the court has jurisdiction over all these claims. Venue's appropriate. Facts common to all counts. So let's start with his death. Before his death, John and Karen were dating. On the evening of the 28th, John and Karen went out. They first went to McCarthy's in Canton, where they had several drinks. Then they went to the waterfall in Canton. There, they met up with a group of acquaintances that included Brian Albert, Nicole Albert, Brian's brother, Chris Albert, his wife, Julie, Jen McCabe, Nicole's sister, and Brian's sister-in-law, her husband, Matt McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home at 34 Fairview. McCabe told John O'Keefe that he should come to the house. The group had overlapping social relationships. At the time, Brian Albert was a police officer, as was Mr. O'Keefe, though they did not know each other well. Brian Albert and Brian Higgins were close friends. Let's keep that in mind. Higgins was an officer at the ATF. He also was permitted to keep an office at the Canton Police Department alongside Brian Albert's brother, Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor. So all these people we know are connected. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, let's see what they say about Colin, was present. Miss Reed and Mr. O'Keefe had never been to that house before January 29th, 2022. They arrived in front of the home at 12:20. Miss Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location, whether they were even welcome to the late night party. John got out of the car and indicated that he would check out the party and report back to her. John walked towards the front door, garage area of the house, and entered one of those doors. Interesting. A period of time passed without any word from John. Karen, who was still hesitant to join, presumed that John intended to stay, and therefore she left to go home without him. At some point after entering the house/garage, John was involved in a physical altercation either inside the house or garage. During that altercation, The Albert's German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating Contacroups. Oh my God, I sound like what's his name, the prosecutor. the wounds on the back of his head. Mr. O'Keefe's head wound was caused by falling backward and striking a ridged surface. The Albert's garage contained such surfaces. By contrast, the head wound could not even have been caused by a vehicle strike or falling backward onto a flat, cold lawn like the Alberts. Because of their knowledge of criminal investigations, the Alberts, the McCabes, and Higgins, House defendants, knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk to their own criminal exposure. Therefore, at least the five of them agreed on a simple plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired, John never entered the house, and hide evidence that he was there, including his body. Sometime during that night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of the area of the lawn for potential passerbys. At some point further in the night, you know what? They did not talk about this Ford Edge during the trial, or at least the second trial, very lightly. At some point further in the night, they carried and dragged John's body to that same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. I think her name is Jen. Not even I think, we know her name is Jen. The plan was devised to make it appear that Mr. O'Keefe had been struck by Karen's vehicle and then died as a result of exposure to the cold. Mr. O'Keefe was either dead when the defendants left him on the lawn or he died shortly after. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. Oh yeah, y'all remember that footage? The nefarious HIG? He later told investigators he had to do some administrative work, but then changed his story subsequently, stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and entering offices while wearing a hoodie to obscure his face. Let's not forget he was also under the influence. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. Man, they're bringing all the tea in this document, Chad. Let's keep going. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Alberts and Higgins denied the existence of these phone calls. And then when confronted with their existence by a separate law enforcement agent at a separate proceeding, they coordinated the same exact lie, falsely claiming the multiple calls and answers were just butt dials. However, 5 minutes after the Higgins and Albert call, Miss McCabe performed a Google search on her phone at 2:27 that read, "House long to die in the cold," misspelling the first word. So that's the first section, chat. Let's get to the next one. Miss Reed searches for John O'Keefe. Miss Reed began the search for John on January 29th, just before 5 a.m., when she awoke and realized he had not returned home. She phoned House defendant Jennifer McCabe, who already knew exactly what had happened to John. Miss McCabe insisted that Karen drive to the McCabe's house rather than driving to Fairview Road, which Reed did. The two of them were then joined by Carrie, and three of them left the McCabe residence. However, rather than going to Fairview, oddly, Jen directed them to go back to John's house, where Karen had just come from. After the three of them finally drove to Fairview, the illogical McCabe-directed route to 34 Fairview was intentional. Oh. Yes, Miss Davis, you could email me. I think it's in the description box. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and the first responders had arrived. As they approached the house with Miss Roberts driving, Karen saw John almost immediately. She screamed for Miss Roberts to stop the vehicle and jumped from the moving car to run to John. She began rendering aid, including CPR, as the House defendants had planned. John's body was discovered in front of the Alberts' house near a flagpole and a fire hydrant on the left side of the property as seen from the roadside. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. While Miss Roberts joined Miss Reed with administrating CPR, Miss McCabe did not help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported that there is a man passed out in the snow. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, just feet away inside the house, Jen never went into the house or requested that the Alberts come down or to help Mr. O'Keefe. Rather, as John lay dying in the snow, Jen stood and watched with no fear, urgency, or even concern that her family members residing mere feet away. So that is the discovery, right? Next, let's get to this section. This is the investigation beginning. The Canton PD were the first on the scene shortly after 6 a.m. At the time, there was no evidence that John had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, his torso, or any other part of his body as investigators would expect from a vehicle strike. Rather, John's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason, the ranking Canton police officer at the time, Michael Lank, opined on a telephone call captured on a dash cam that John looked like he had been in a fight. Moreover, the initial search conducted by Canton police revealed that there was no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near John's body. Not a single piece of taillight material was discovered on the lawn that morning or in the roadway, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Miss Reed's screams upon finding John's body, no one from the Alberts house, including police officer Brian Albert, ever went outside to see what was happening, let alone help. They wanted to avoid scrutiny from police investigators. Now, Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabes. Pursuant to their plan, the Alberts and the McCabes told Lank that John had never entered the house the night before. The Alberts and McCabe's statements were false. Mr. O'Keefe arrived at and entered the house or garage, where he was assaulted, attacked by the Alberts dog, and suffered a fatal injury to the back of his head. Despite John's injury being wholly inconsistent with the story the House defendants were now telling him, neither Lank or any other of the Canton police officers searched the house to determine whether the occupants or anyone else were involved in John's death, nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where John's body was found. They failed to do so because this bias born of friendship and loyalty in favor of the Alberts and McCabes. After Lank returned to the Canton Police Department 3 hours after the discovery of John's body, more than 2 hours after being interviewed by the Alberts' home and morning, Miss McCabe called Lank to report she recalled additional information. So Jen called Sergeant Lank. As a part of their plan to implicate Miss Reed and remove suspicion from the House defendants, she falsely told Sergeant Lank that Miss Reed told her twice that morning, I hope I didn't hit him. More than a year later, in a separate proceeding, Jen changed her story on this topic yet again. In furtherance of the House defendant's plan, Jen then falsely reported that Miss Reed outright confessed to hitting John right after she first found him in the snow. All right, so that's Jen. Now let's talk about good old Mr. Proctor. Michael Proctor was assigned as the case officer and had primary responsibility for the investigation over John's death. Buchanan was Proctor's supervisor. Tully was a supervisory officer at the State Police Detective Unit, and thus supervised both Buchanan and Proctor. In their roles, Buchanan and Tully both knew all the times exactly the extent of Proctor's misconduct in investigating John's death. From the beginning, Proctor should have never been assigned as an investigating officer, let alone the lead investigator. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, they had their cell phone numbers. In fact, just days before John's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister was also a close friend of Julie. In fact, Proctor's own mother referred to the Alberts as the Proctor's second family. Damn. The existence of these relationships was intentionally suppressed by Proctor and other members of the police, including Buchanan and Tully, in an effort to ensure that the House defendants were protected and that Karen's right to a fair investigation and trial were undermined. Proctor, Buchanan, and Tully engage in a corrupt and biased investigation by not investigating inside of the House, interviewing the House defendants as friends rather than suspects. Proctor, Buchanan, and Tully never searched for DNA evidence inside the house, never looked for ridge surfaces that could have caused a gash in the back of John's head, never inspected the house defendants' bodies for indication of bruising, cuts that resulted from an altercation, and did not search the house defendants' cell phones. This allowed potential evidence to be destroyed, disposed of, removed, and simply become unrecoverable. Proctor, Buchanan's, and Tully's interviews of the house defendants were also outside of normal protocol. They were all interviewed either at their home, the family member's home, their lawyer's home in the case of Higgy, their lawyer's office in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the House defendants, and the House defendants took full advantage of it. Specifically, Jen became the point person for all the House defendants, providing their false narrative to investigators. Damn, they're coming for Jen's neck, all right? Like, Ben, be careful. Watch out now. She managed and communicated details about the House defendants' messaging and investigation itself, including visiting Proctor's and other investigators' private residences, mapping out timelines. That's right, she made a timeline to coordinate statements with the other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy among a group of people who, with a shared goal of deflecting their criminal exposure onto someone else. The remaining group texts that were not deleted or that were recovered later revealed some of their planning. For instance, on the evening of the 29th, Jen texted her sister Nicole, and Carrie, who was present when John's body was found, said, "Talk to cops," and kept it simple. Jen? Of course, there'd be no reason to report back to other House defendants about Roberts keeping it simple unless what really happened was more complicated. Proctor, Buchanan, and Massachusetts State Police never sought these communications. Rather, they were obtained by Karen Reed's defense attorneys, repeated motions to compel access to data on Jen's iPhone. So the defense team found these texts, not the police. Later, in group texts with Jen McCabe, Brian and Nicole Albert, Matt McCabe suggesting having Chris Albert publicize their crafted story to a reporter saying, ask Chris to ask some questions. Tell them the guy never went in the house. As an endorsement of the plan, Brian Albert responded, exactly. Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provide a window into their conspiracy and misconduct, as well as the police awful investigation, were not a product of Canton PD or Mass State Police investigative work. Rather, based on media reports raising serious questions about the police investigation and the House defendants' role in John's death. Another separate law enforcement agency began its own subsequent investigation. That investigation, not Massachusetts State Police, resulted in obtaining the House defendants' phones, taking statements from the House defendants, and conducted a separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by the separate law enforcement agency investigation demonstrates the House defendants' conspiracy on unlawful conduct, as well as MSP's bias and corruption. Proctor and Buchanan initially interviewed the McCabes and Albert on the 29th at the McCabes' home in Canton, at which time they falsely stated that John never entered the house. Proctor and Buchanan did not interview Nicole Albert and Brian Higgins until February 3rd. So look at those dates, chat. January 29th, February 3rd. And did not interview Chris and Julie Albert until February 10th, even worse. Nearly 2 weeks after John's death and more than a week after Miss Reed was arrested and charged. Before both interviews, the McCabes and Alberts continued to coordinate their stories as evidenced in group texts. Proctor, Buchanan, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Buchanan interviewed Higgins on February 3rd, Higgins presented the troopers with a select set of self-curated texts between himself and Karen. They learned that Brian, Higgins, and Karen had been exchanging flirty texts and that Higgins reported at least one instance on which Karen and Higgins had kissed while John's house, in which Karen and Higgins had kissed while at John's house mere weeks before his death. Rather than pursuing Higgins as a possible suspect, Proctor, Buchanan, and Tully neglected to investigate the matter further. They never interviewed Higgins again. Even after the surveillance video revealed Higgins was suspiciously hiding his face in the halls and in the parking lot of Canton PD at 1:30 a.m. on the 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and MSP not investigate what Higgins was doing or what was in the bag, but they went so far as to hide this video from Karen and her criminal defense attorneys for years. Man, listen. Reed's defense did not receive these videos until after Reed stood trial for the first time. And even after that separate law enforcement agency's investigation revealed the late night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further or seek a full forensic extraction of Higgins' phone or even a simple call log from his cell provider. When it was revealed that Miss Reed's defense team requested the preservation of the phones in order to forensically image them, this request was allowed by the court. Both men got rid of their phones within days of one another. Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from his phone, cut the SIM card with scissors he bought with him, and destroy and dispose of the phone and card separately in 2 dumpsters, then drive back home. Their destruction of their phones eliminated potentially incriminated communications between them and was a direct result of Proctor, Buchanan, and Tully's intentional refusal to collect important investigative evidence that would have been exculpatory to Miss Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue the evidence, such as cellular toll records or simply interviewing Brian Higgins and Brian Albert to inquire about the nature of the late night communications. They intentionally ignored these avenues as well. Not only did Proctor fail to probe his friend's stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, and at least 67 times between February 1st and September 6th. That is a large window. For example, Chris and Julie Albert on February 10th, Proctor told his sister Courtney that an interview was not a big deal. Courtney told Proctor that Julie had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. Proctor shared investigative details with Courtney before they were public. In the same instance referenced above, his sister informed him that Julie Albert had been so nervous before the interview. Instead of investigating further, she shrugged it off, laughed, and asked why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick convo. Then after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Proctor never treated the Alberts as witnesses in the murder investigation. He treated them like family friends that they were. At one point, leading up to some of the interviews, Miss McCabe asked Nicole Albert if she heard anything more about the investigation. Confident that she would learn more from Julie, again through Courtney, Nicole Albert responded, "We'll get more info tomorrow. Don't want to text about it." Why? House defendants did not want to text about their activities and communications because they tried to hide or lie about them. For instance, it was discovered in the second criminal trial that Jen had lied in her sworn testimony about the first trial about not visiting 34 Fairview with Carrie Roberts on their way to Michael Lang's house. However, while they did not text about this meeting, Jen's cell phone location data obtained later by Karen's defense team reveals that she did, in fact, visit 34 Fairview just one day after John's death and lied about it. The McCabes, Alberts, and Higgins all told the same false story to investigators in their interviews, and Proctor, Buchanan, and Tully accepted their coordinated statements without making efforts to corroborate their stories. So that's the thing. That is the thing. You know, you gotta do real investigative work, double check, trust but verify. Rather than investigate their friends and brethren. Who did that? Rather than investigate their friends and brethren, Proctor, Buchanan, Tully, and Massachusetts State Police target Karen Reed. Instead of taking the routine, objective, and necessary steps of investigating the McCabes, Higgins, and the Alberts, Proctor, Buchanan, and Tully focused exclusively on Karen as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Karen's cell phone, her SUV, within 30 minutes of interviewing her on the 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage before interviewing exculpatory witnesses, and before the medical examiner's final official conclusion that the manner of death could not be determined and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Much to Proctor's surprise, through the separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of the 29th, the day he began his investigation. He told them that the MSP had already determined that the Alberts were not going to receive any scrutiny about John's death, even though the MSP had not at that point visited the crime scene or been inside the Alberts' home, and had performed only a cursory interview of the McCabes and Brian Albert. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike, but did have injuries consistent with a fight and a dog attack. Proctor rejected a friend's belief that Brian Albert and the homeowner of the property where John's body was found would receive some shit, instead of agreeing with another friend's assumption that you guys are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided where he was going to put serious charges on Karen, that she was fucked, and that there was zero chance she skates. From the outset, Proctor was determined to pin it on the girl. Proctor's supervisors were aware of his bias and conflicted relationship with the investigation. They didn't have to guess. Proctor told them. He told them that he knew the Alberts. Text messages from Proctor to Buchanan and other MSP troopers show Proctor had decided to focus suspicion on Karen to the exclusion of everyone else. He told the troopers that Karen was retarded and that she was searching her phone for nudes of her. In the text chain, Sergeant Buchanan liked Proctor's text describing Karen as retarded. Buchanan received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Because he was determined to put serious charges on Karen, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that John's death was a homicide, determining instead that the manner of death could not be determined. The medical examiner also refused to conclude that John died as a result from being struck by a car, and later testified at trial that his injuries were not consistent with a car strike. Proctor later admitted that in his entire career, he had never seen a homicide investigation where the medical examiner could not determine the manner of death. But he remained undeterred in his quest to charge Karen. He later admitted the medical examiner's refusal to rule the death a homicide did not matter to him, because either way, Karen was going to be charged. Next section. Proctor and Buchanan plant certain evidence and make false statements in court and other legal documents to frame Karen. Well, let's get into it, because this might be the most important part of this document, of this complaint. Here we go. Proctor made his investigation cut and dry by manufacturing a case against Karen. A first crucial step was to ensure the crime scene and evidence was not secured. This was a violation of MSP policy and well-established best practices for critical incident investigations. Specifically, the MSP Crime Laboratory requires proper processing of a crime, proper processing of evidence at major crime scenes, including crime scene photography and evidence processing and recovery of latent fingerprint, footwear, and tire track evidence. Neither of the MSP troopers involved in the investigation nor the CPD police officers on the scene secured the Alberts' home or the area where John's body was found. The MSP did not take any photographs of the house, including any part of the yard where his body was found, until February 1st, more than 3 full days later. No photographs were ever taken of the inside of the garage of 34 Fairview. This intentional departure from established protocols permitted Proctor and Buchanan to generate false incriminating evidence against Karen and give the House defendants time to destroy the actual evidence. By approximately 2:30 on the 29th, before he had even met or interviewed Karen or seen her car, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17, the vehicle was in the custody of MSP. The vehicle was then towed to CPD, the Sallyport, even though MSP has at least 2 closer barracks and Massachusetts was in the middle of a historic nor'easter. Proctor knew he had more leeway to manipulate the evidence regarding the SUV at Canton than at MSP's facilities, and he knew he needed to have that evidence in close proximity to the crime scene at 34 Fairview. Before the vehicle had arrived at the garage, Karen's Lexus taillight had a minor crack, but was intact. The crack occurred when Karen backed into John O'Keefe's car at 5 a.m. as she was leaving to search for him. That incident was captured on video. Buchanan and Proctor followed the vehicle from Dighton and arrived at Canton at 5:35, just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right rear taillight was almost entirely destroyed. Video taken from different angles in the Sallyport shows Buchanan, Proctor, and Police Chief Berkowitz and other individuals near the taillight. But notably, no video captures the taillight's appearance at the precise time it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as CPD access card swipe log obtained by a separate law enforcement agency revealed seemingly unfettered access to the Sally Port by a myriad of individuals throughout the evening of the 29th, including just before and just after 5:30. One or more of them destroyed the taillight, secretly took pieces of it into their possession, and then planted some of them in various places at 34 Fairview on Mr. O'Keefe's clothes. Oof. This is riveting, guys. Knowing that there were video cameras both inside and outside the Sally Port, Proctor and Buchanan worked together to obscure their role in manipulating the right rear taillight, then ultimately to present false evidence at the first criminal trial. Specifically, Proctor directed Buchanan to secure video footage from the surveillance cameras located both inside and outside the Sally Port garage, which he did. These videos were manipulated in two significant ways. First, the critical 42-minute portion was deleted from the footage from the Sally Port front wall camera, the portion of 5:08 to 5:50, which included the exact time Karen's Lexus arrived at the garage. This footage would have shown that the taillight was intact. Second, footage from the Sally Port back wall was inverted, which made the right side of Karen's vehicle appear to be the left side and vice versa. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived to CPD, but it was too grainy to decipher the condition of the passenger taillight. The videos from inside and outside the Sally Port and Proctor's request for Buchanan to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera footage was not revealed to the defense until just prior to the start of the second trial. In fact, Buchanan presented one part of the video during his direct testimony under questioning by the Assistant District Attorney, Adam Lally. Buchanan narrated the video to the jury, correctly identified that Proctor was at the rear of the vehicle, but claimed he never approached the right rear taillight of the vehicle. That testimony was entirely false. As he well knew, the video that Buchanan authenticated as fair and accurate was actually neither fair nor accurate because it had been inverted. Proctor was actually behind the right taillight for a significant period, but because it was inverted, it appeared that he was behind the left taillight. They hoped this would allow Buchanan to lie about this issue at trial without detection. With this video and Buchanan's false testimony, the MSP, Proctor, and Buchanan attempted to mislead the jury in order to conceal the tampering with and planting of taillight material. Proctor and Buchanan also, I lost my spot. Hold on. Proctor and Buchanan also took taillight pieces from the Sally Port, brought them back to Fairview to plant them in a location where John's body was found, and falsified various documents in an attempt to hide their conduct. And warrant application to Stoughton District Court and Norfolk Superior Court for searches of Google's electronic records, Ring videos, Karen's phone and Karen's vehicle, cell towers, and other sources of information. Proctor swore he seized Karen's vehicle from her parents' home at 5:30 and had the vehicle towed to Canton PD. Reports shared by Dighton police revealed that the Lexus was towed from Dighton at 4:17. He said 5:30. Proctor's assertion that he seized it at 5:30 was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces from the taillight from Karen's vehicle and bring them back to the house so he could later claim the pieces had been there since 12:30 on the 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton police revealed that Proctor lied and revealed the true and accurate time the Lexus came to MSP's possession. Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sally Port on John's clothes. Proctor retrieved John's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag, as protocol requires, Proctor and Buchanan drove them around in his car all day and then placed them at the Norfolk County District Attorney's Office for at least 6 days, where they were accessible to Proctor, Buchanan, and other MSP troopers. Proctor and Buchanan failed to create a log to document the chain of custody for the clothing. Therefore, and by design, there is no record of when and how many times and under what circumstances Proctor and Buchanan touched, manipulated, handled, or otherwise tampered with that clothing. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection and that the collector seal those packages as soon as possible after collection to ensure integrity of the evidence and the items and limit loss of transient evidence. Here, in violation of MSP's stated policy, the chain of custody for all of John O'Keefe's clothing, as well as a dozen pieces of taillight material, does not begin until March 14th, nearly 2 months after it was collected, when Proctor finally submitted to the MSP crime lab. At some point before providing those clothes to the same lab, Proctor and or Buchanan placed pieces of the SUV taillight on them, where they were identified by the crime lab in 2023. Proctor also planted pieces of taillight on Karen's bumper while it was still in his possession at the Sallyport garage, where he then claimed to have recovered them on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that John was holding when he exited the waterfall. Evidently, Proctor did not plan on Karen's defense attorneys insisting on forensic testing on the glass shards that showed they did not match the cocktail glass in John's possession. Wow. In fact, the 5 glass pieces originated from multiple different sources. One shard of glass in the bumper did match the piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of John O'Keefe. Hoo-wee, chat. We're almost there. Let's keep going. Proctor, Buchanan's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite the evidence that Brian Albert may have had surveillance footage at the house, neither Proctor or Buchanan nor any member of MSP issued subpoenas to Ring or any other home surveillance company. Right? Like, why wouldn't that be the first thing that you do? Why wasn't that the first thing that they did? If somebody got hit by a car outside, hey, can I look at your surveillance footage? Why wasn't... They've got a point here. Proctor and the MSP also failed to track down any other important witnesses and evidence. For example, Brian Loughran, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial. Proctor and his colleagues never spoke to him during the investigation, and only did so once Loughran was interviewed by a separate law enforcement agency and provided statements inconsistent with MSP's narrative 18 months after Reed had already been indicted and was waiting for trial. Specifically, Mr. Loughran drove his snowplow by the house multiple times in the early mornings of that night, including at 2:30 and 3:30. He reported that there was no body on the lawn at 34 Fairview, nor any cars in front of the house at 2:30. Mr. Loughran believes that he would have seen a body had it been on the lawn where O'Keefe was found several hours later. Instead, the second time he drove by the house at 3:30, Mr. Loughran saw a Ford Edge in front of the Albert's home that had not been there the hour before, which was then parked where his body was later found. Brian Albert drove a Ford Edge at the time. Oh, it was your car. However, the Ford Edge was gone by the time Karen arrived at the house at 6:30. and in its place, she discovered John's body. Proctor, Buchanan, and Tully never made any effort during the actual investigation to track down Mr. Loughran or any information related to the Ford Edge. Proctor also secretly made efforts to protect the Albert family members during the investigation who may have had a role in Mr. O'Keefe's death. Witness Julie Nagel told Proctor that Colin Albert, here we go, it's Colin time, Brian Albert's nephew, had been present at the house the night of the 28th, 29th, but Proctor omitted his name from the official summary of Miss Nagel's interview, even though he listed all others who had been present at the house with Colin. When Miss Reed's lawyers followed a motion to obtain Proctor's notes, his handwritten memorialization of Julie Nagel interviewed mirrored almost exactly what was typed up in the police report, except for the words Colin Albert. Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationship with the Albert family, as well as his propensity for violating MSP rules in Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin, a Canton police officer, instead of official channels when he was coordinating interviews of witnesses, even though CPD was recused from the investigation. Further, the middle of Proctor's investigation in the summer of 22, it discovered that Proctor and Kevin were out drinking alcohol and driving in Proctor's cruiser in Cape Cod. At the end of the night, Kevin Albert forgot to bring home his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's vehicle violated both MSP policies as well as several Massachusetts criminal statutes, and later highlights the conflicted nature of MSP's investigation. Moreover, because of their close relationship, Proctor, Buchanan, and Tully worked together with CPD in hiding certain videos from Karen's criminal defense team. Specifically, upon information and belief, MPD and CPD collaborated to keep exculpatory surveillance video from Karen's criminal defense team in preparation for the first trial. Those videos captured Brian Higgins' activity at CPD in the parking lot and inside the police station shortly after the physical altercation at the house that led to John's death. They demonstrated that Higgins' statements about his post-house party activities the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Karen. Additionally, upon information and belief, CPD set its auto-delete function for saving certain surveillance videos at the Sally Port to 30 days, therefore assuring the immediate destruction and likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPD videos were shared with the defense over the course of 3 years. Therefore, either the setting was changed to prevent the defense expert from auditing the footage, or the footage was obtained within 30 days of January 29th and withheld from the defense. The indictments, trials, and the aftermath. Karen was arrested on February 1st, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post $50,000 for bail, and the court imposed several other conditions of release, including loss of her driver's license and stay-away orders from the O'Keefe family and John O'Keefe's home. Karen was later rearrested on June 9th after being indicted for a second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February of 23, her bail was reduced to $80,000 at the defense's request. Ms. Reed was tried twice by the Commonwealth. The first trial started in April of 24 and ended on July 1st after the court ordered a mistrial because of a hung jury. On June 18th, following another nearly 2-month trial, Karen was acquitted of all charges associated with the death of John, murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Karen was able to leave court knowing that the forces aligned against her had failed to convince a jury to buy their deception. Beginning on January of 2022, the defendant's actions have had profound effect on Karen. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars of debt for legal fees and additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, tried twice, she has suffered years of intense stress and emotional harm, worried that she would be in prison for the rest of her natural life for a crime she did not commit. Whoop, what is happening over here? We switched from I don't know what happened there. I don't know what happened to my marker. I want a highlight, not a marker. Okay, there we go. It's fixed. Sorry, guys. Karen suffers from both Crohn's disease and multiple sclerosis. As documented under seal with the criminal court, Ms. Reed has undergone tons of surgeries to manage her illnesses prior to January of 2022 and endured a blood infusion just months before John's death. In aftermath of charges to arrest in both trials, Karen suffered a well-documented exacerbation of her symptoms and amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Karen underwent dozens upon dozens of documented medical procedures and treatments to attempt to address her health issues. The defendants concocted a plan, executed that plan, and framed an innocent woman, and they are now responsible for these extraordinary damages Karen has suffered at their hands. All right, MSP investigates and punishes Proctor, Buchanan, and Tully for their misconduct during the investigation. Proctor wrote more than 1/3 of the police reports in this case, testified at the state grand jury in 3 separate times, interviewed every member of the Albert and McCabe families, had possession at least until March 14th of all of John O'Keefe's clothing and all of the taillight pieces found from broken from the housing, processed John O'Keefe's Chevy Traverse the day after Karen was arraigned, had access to and reviewed all the ring footage, had access to and reviewed the surveillance from C.F. McCarthy's, had possession of all the Sallyport and driveway videos, and numerous other critical investigative activities. And yet, once evidence of Proctor's conflicts and lies became public, he was extradited from the case, and in an effort to hide him from the jury and sanitize a compromised investigation while Karen was forced to trial, not once, but twice. Ultimately, Proctor was relieved from duty and transferred out of the detective unit on July 4th of 2024, mere days after the conclusion of Karen's first trial. Proctor was terminated on March 19th of 2025. Upon a release from the district attorney of more implicating text messages from Proctor's phone, on October, this was last month, 18th, 2025, Proctor officially ended his appeal with the Civil Service Commission. On September 23rd, MSP Internal Affairs investigation found Buchanan failed to perform his supervisory duties in an ongoing investigation. On July 7th, 2025, Buchanan was transferred out of the NDAO detective unit and reassigned to administrative role in another division. On October 18th, Tully was disciplined and reassigned and stripped of his detective designation. Tully was given special dispensation by the Norfolk County District Attorney Michael Morrissey to continue detective work on the Reed case despite his demotion because of his behavior on this case. Upon information and belief, MSP troopers DeChico and Kotkowski were also disciplined for their misconduct associated with MSP's investigation of Karen. All right, chat. Let's look at the counts. Count 1, malicious prosecution under the Fourth Amendment against Proctor, Buchanan, and Tully. The preceding paragraphs are incorporated herein by reference. Proctor, Buchanan, and Tully violated Karen's Fourth Amendment rights by engaging in malicious prosecution of Karen by causing her to be seized pursuant to legal process unsupported by probable cause. The criminal prosecution against Karen terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Proctor, Buchanan, and Tully caused Karen to be seized without probable cause as described above, including but not limiting to leading, handling, and participating in John's investigation, even though Proctor was conflicted due to his personal relationships with various witnesses, suspects, and potential suspects, which conflict led to Karen's unlawful treatment, handling the investigation, even though Proctor had an extreme and personal negative bias towards Karen, which bias led to Karen's unlawful treatment, violating MSP's rules, policies, and procedures in all aspects of the investigation, planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committed perjury. Wow, so they're saying y'all just lying. Failing to secure evidence on a crime scene, obtain evidence, timely and appropriately interview suspects, and investigate the Alberts, McCabes, and Higgins, and allowing them to destroy potentially exculpatory evidence. Failing to consider to present exculpatory evidence to prosecutors and the grand jury investigating John's death, such as the evident dog bite injuries on John's arm, and evidence that his injuries were caused by an altercation, not by a vehicle strike, such as the lack of lower body trauma. Following her indictment by grand jury, Karen was rearrested without probable cause, forced to pay $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. Those post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Those deprivations continuing during Karen's second trial, and in part because of Proctor's false testimony at Karen's first trial. Among other things, Proctor falsely testified. Oh, they have a list. Let's go through Proctor's lies, shall we? 1. When he first saw the taillight on Karen's car at Karen's house in Dighton, it had large pieces missing, and the shattering taillight displayed at the first trial, as photographed on February 1st, was in the same condition as it was on the 29th. Next, he and Buchanan never touched any part of Karen's car when it was stored in the Sally Port. Next, he retrieved taillight pieces on subsequent searches at the Alberts' home when he knew he had deposited, or arranged for someone to deposit taillight pieces at the property. Next, Chris and Julie Albert were his loose acquaintances rather than friends. And next, his statements and sworn affidavits all claiming that the Lexus was seized at 5:30 when he arrived at Dighton at 4:30 were typos. So they're like, oh, it's a typo. You just lied. Like, you just lied. Thus, Proctor, Buchanan, and Tully, acting under the color of law, violated Karen's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this conduct, Karen was wrongfully prosecuted for John's death and made to defend herself in 2 trials in the Superior Court of Norfolk County, resulting in loss of employment, reputational damages, and millions of dollars in legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages to these harms, Karen is entitled to her attorney's fees, costs, interest, and punitive damages. So that's count 1 against the cops. Here's count 2. We're looking at supervisor liability. This one's against Buchanan and Tully in their individual capacities. The supervisor is liable under this law, right? When the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result into deprivation of an individual's constitutional rights. Buchanan and Tully knew, or should have known, that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship, which he had disclosed. They also knew, or should have known, that there was a risk that Proctor would wrongfully seek to have Miss Reed charged, given the manifest bias against his text messages, which were sent to Buchanan, amongst others. That's true. That's true, because Buchanan hit the thumbs up on one of them instead of being an actual supervisor. Buchanan and Tully could have taken easily available steps to avoid constitutionally deficient malicious prosecution of Karen. Those measures include, but are not limited to, maybe replacing Proctor with an unbiased investigator that had no relationship with anybody involved in this death. Maybe safeguarding the crime scene and the physical evidence, including John's clothing and 47 pieces of tail light, to prevent anybody from planting, manufacturing, or manipulating the evidence. Maybe initiating timely searches at the Alberts house, or maybe quickly seizing the cell phones and other forms of electronic evidence in the possession of the Alberts, McCabes, and Higgins, which would have prevented their later manipulation and destruction. By not taking any of these measures, Buchanan and Tully permitted Proctor, and Tully permitted Buchanan to violate Karen's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violated Karen's Fourth Amendment rights. In these ways and others, Buchanan's conduct constituted condemnation of or acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. In these ways and others, Tully's conduct constitutes condemnation of or acquiescence to Buchanan and Proctor's behavior or gross negligence amounting to deliberate indifference. As a proximate cause of their breaches, Karen was wrongfully prosecuted for John's death, resulting in loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to award of damages for these harms, Karen is entitled to her attorney's fees. So those are 2 counts so far. So the first are against the cops. The second is against the supervisor. Here's the third. Count 3, conspiracy to deprive Karen of her Fourth Amendment rights. This is against everybody. Proctor, Buchanan, Tully, the Alberts, the McCabes, and the Higgins. So count 3 applies to everybody in this lawsuit. Proctor, Buchanan, Tully, the Alberts, McCabes, and Higgins shared a common design and acted in concert to frame Karen for John's death. As a part of their concerted efforts and among many of their misrepresentations, all these people agreed with each other to tell investigators that John never entered the house, that they did not see John in the house that night, and that Karen made inculpatory statements the morning of the 29th. When they made those statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Karen. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating John went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Karen to the exclusion of everyone and anyone else. In furtherance of this plan, among other unlawful conduct, Proctor, Buchanan, and Tully agreed, 1, to continue to handle the investigation even though they had personal relationships with the suspects in the murder, which led to unlawful and favorable treatment of the potential suspects, to continue to handle the investigation even though they had biases against the investigating House defendants because the House defendants' ties to law enforcement, to continue the investigation even though they had exhibited an extreme and personal negative bias towards Karen Reed, to violate rules, policies, and procedures in all aspects of the investigation, to plant, manufacture, and manipulate evidence, falsify documents, and commit perjury, to not secure evidence in the crime scene, to not investigate and obtain available evidence or timely, appropriately interview suspects, and to not investigate the Alberts, McCabes, or Higgins. The Alberts and McCabes coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and texts on their phones, which were later destroyed and discarded. Finally, Proctor, Buchanan, and Tully coordinated with the Alberts and McCabes through Proctor's sister, Courtney, who communicated frequently with Julie Albert. Come on, what happened to my... There we go. Just making sure. I can't stand that marker, y'all. I need my highlighter here. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabes and Brian Albert in a cursory manner, and all at the same location, midday on the 29th, and Nicole Albert on February 3rd. Proctor and Buchanan only interviewed Higgins once at his attorney's home and did not secure or search his phone or search for his communications between him, the Alberts, and McCabe's. Proctor and Buchanan did not search the Alberts' phones or home, which was likely containing evidence of John's murder. Brian, Albert, and Higgins destroyed or discarded their phones, destroying the evidence of the murder and the cover-up. As a result of the conspiracy between and among them, Proctor, Buchanan, and Tully never investigated the House defendants, and instead Karen was wrongfully arrested and persecuted in violation of her Fourth Amendment rights. Proctor, Buchanan, and Tully, and the House defendants acted in unison and had a peculiar power of coercion over Karen because Proctor, Buchanan, and Tully were the state's police employees investigating John's murder, and the House defendants were able to direct that investigation solely towards Karen because of their professional and personal connections to Proctor, Buchanan, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. The proximate results of Karen's wrongful prosecution was her loss of employment, reputational damages, millions of dollars in legal expenses, and serious emotional and physical distress. In addition to an award of damages, she wants her attorney's fees back. That's count 3. Count 4, Massachusetts Civil Rights Act, against all of them. The preceding paragraphs are incorporated by reference. Proctor, Buchanan, and Tully, and the House defendants interfered or attempted to interfere with Karen's exercise or enjoyment of her rights under the federal and Commonwealth constitutions for laws through threats, intimidation, and coercion. Among other acts, by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts or Higgins' phones, and ignoring exculpatory evidence such as dog bite injuries, the lack of injuries consistent with a vehicle strike. Proctor and Buchanan caused Karen's wrongful indictment, arrest, and prosecution, and thereby interfered and attempted to interfere with her rights under the Fourth Amendment by falsely representing that John never entered the house and by relocating his body to the location where the Alberts property where they could claim Karen dropped him off. All of these people caused Karen's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Karen's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The House defendants therefore interfered and attempted to interfere with Karen's rights under the Fourth Amendment of the Constitution and Article 14 of the Massachusetts Declaration of Rights. Karen's wrongful indictment, arrest, and prosecution were intrinsically coercive under mass law. However, the House defendants and the Proctors, Buchanan's, and Tully's conduct amounted to threats, intimidation, coercion, designed to force Karen to give up her defense and plead guilty to a crime she did not commit. As a proximate cause of the defendant's action, Karen was wrongfully prosecuted for John's death, resulting in loss of employment, reputation, millions of dollars in legal expenses, as well as serious emotional distress and injury. Count 5. Common law malicious prosecution. This is everybody. By manufacturing and planting evidence, not securing the crime scene, not searching the homes, all of that stuff, ignoring the dog bite injuries, lack of injuries consistent with a vehicle strike. Proctor, Buchanan, and Tully caused Karen's indictment, arrest, and prosecution. Okay, this is kind of repeated, so I'm going to skip some of this. These criminal proceedings were instituted with malice as evidenced by Proctor, Buchanan, and Tully's knowledge that it would be based on false evidence, their bias and ill will towards Karen, and for improper purpose to protect Proctor's friends and acquaintances, the Alberts. The criminal proceedings terminated in Karen's favor when she was acquitted of murder, manslaughter, and leaving the scene with a death. By falsely representing that John never went in the house and by relocating his body to the location where Jen would claim that Karen dropped him off, all of these people caused Karen's wrongful indictment, arrest, and prosecution. Higgins and Albert caused Karen's wrongful indictment by destroying their phones. As a result, she was wrongfully prosecuted. Count 6. Of course, IIED, intentional infliction of emotional distress. So it sounds like we're landing the plane soon. By manufacturing and planting all this evidence, ignoring the dog bite injuries, lack of vehicle injuries, Proctor, Buchanan, and Tully caused Karen's indictment, arrest, and prosecution by falsely representing that John went in the house, relocating his body, and getting rid of their phones. They caused this to Karen. The defendants knew or should have known that their conduct would cause Karen emotional distress since it would lead to her prosecution. And the result was Karen suffering from severe emotional and physical distress. The defendant's conduct perverted the justice system, allowing John's true murder or true killer to escape liability and threatening to imprison Karen. It is a type of behavior that threatens civilized society and is therefore extreme and outrageous. The proximate result of Karen's actions, Miss Reed suffered serious emotional and physical distress and injury. I think this is the final count coming up here, civil conspiracy. This one is against all of them as part of their concerted efforts and among many other misrepresentations. All of these people agreed with each other to tell the investigators that John never came in the house and they never seen him that night, and that Karen made inculpatory statements. When they made these statements, the House defendants did so only because they were aware that Proctor and Tully would also act similarly by solely investigating Karen. Proctor, Buchanan, and Tully knew or should have known that these statements made by the House defendants were false and that obvious and easily obtainable evidence existed demonstrating John went into the house where he was involved in a fight. He hit his head and was attacked by a dog. Instead, because of their close relationship, they all agreed with each other that they were going to make these misrepresentations. And they were going to target Karen to the exclusion of everyone and anyone else. In further of the conspiracy, Proctor, Buchanan, and Tully agreed to fabricate, plant, and manipulate evidence purporting to show that Karen's vehicle hit John. Pursuant to their plan, they carried out multiple acts, including damaging the taillight, not securing the crime scene, depositing taillight pieces prior to the CERT team arriving on site. That's interesting. In addition, Proctor deposited some of the broken taillight pieces on John's clothes while it was in his unprotected custody. Proctor also deposited glass alleged to have been from a cocktail glass on Karen's SUV. Another part of the conspiracy was to take coordinated steps to ignore and destroy the evidence that pointed to other suspects like Higgins and Albert. The McCabes, the Alberts, and Higgins coordinated through text messages, phone calls. Higgins and Brian Albert communicated through phone calls, texts, which were later destroyed. Finally, Proctor coordinated through his sister Courtney. Acting pursuant to that plan, Proctor and Buchanan interviewed the McCabes in a cursory manner, and Nicole Albert on the third. All told the same false story that John never came in. Proctor, Buchanan, and Tully also interviewed Higgins once. Pursuant to the coordinated plan, Proctor, Buchanan, and Tully did not search the Alberts' phones or home. Okay, and then we know that Higgins and Albert destroyed their phones. Sorry if I'm rushing through it, guys. It's just when it comes to these count sections, things start to get a little repetitive. Following the O'Keefe's death, among another set of acts, the McCabes and Alberts agreed to make it look like that John died due to the exposure of being hit by Karen's car. As part of the common plan, Albert and Higgins, both law enforcement officers familiar with investigations, communicated at 2:22 a.m. After Higgins left the house, shortly after, as part of the plan, Jen deleted the Google search at 2:27 a.m., 5 minutes later, for how long it takes for a person to die in the cold. One or more of them relocated John's body and deposited it in front of the Albert's house, where Jen McCabe claimed that that's where Karen dropped off John. The McCabe and Alberts then coordinated that they would say to police, all of them falsely telling investigators that John never entered the house. Okay, everybody acted in unison and had peculiar power of coercion over Karen because of Proctor, Buchanan, and Kelly. They were state police employees investigating John's murder, and the House defendants were able to direct that investigation solely towards Karen because of her personal and professional, or their personal and professional relationships to Proctor, Buchanan, and Tully. It's getting a little repetitive. All right, let's land the plane, chat. Here we go. She is requesting a jury and the prayer for relief. What does Karen want here? Karen wants a judgment in her favor against each relevant defendant on each count of this complaint. She wants damages in the amount to be calculated at trial. She also wants her attorney's fees back, and she wants any other relief the court seems equitable and just. And here we go. We have two law firms representing Karen. So you have Alan Jackson is his law group, and then Sheehan, Finney, Bass, and Green here in Boston. You have to remember Jackson is out of LA, and whenever you're doing work pro hoc vice, you do need to work with a local law team. So we did it, chat. We did it. What do you think? This is, and I'll talk to you a little bit about what happens next. This is just a complaint. And I'm not saying that lightly. This is the first phase of a lawsuit. So although this is filed, all of those defendants get a chance to respond. So we're starting the process of Karen Reed suing these people. They are going to have an opportunity to respond, and we're kicking off the trial process. It could take a few months. It could take a few weeks to get some of these things. Whenever a complaint is filed, the answer usually is due by a certain deadline. So we have to go through all of those things. Once those two documents are filed, we start going through discovery, other preliminary things, and then it lands in the courtroom. So this might be something that we do see in 2026. Again, we have the civil lawsuit where John's family is suing Karen. That is still in play. But now you have this second lawsuit where Karen's suing all of these people. And again, during the hearing that we saw in October, we had the judge, before he retired, say, hey, are you sure you want to put everything together, because it's going to complicate the process. If you separate it, Karen, and if you go after them separately, then we can take care of this case in the spring. So I think that that's where we're heading. The other case with the O'Keefe family suing Karen in the bars, that's going to move forward, right? But it's likely we're going to see that one kick off in the spring. I think he said March. So now that this has been separated, that case is going to go first, and then we might see this one maybe end of 2026 or early 2027 is my projection. But it's about to get crazy. You thought you heard the last of Karen Reed. You did not. You did not. You have not heard the last of Karen Reed. Let me read some super chats, and then I'm going to get out of here, guys. I just read a very long document, so I'm going to go have some lunch after this and hang out for a bit. But shout out to Senator. Good to see you. Hits me with a $5 super chat. Thank you so much, Senator. Appreciate you coming to every single live stream. We're doing so many cases over these next few weeks. This is one that I wanted to just circle back to. I'll be honest, I'm not a fan of Massachusetts right now, or, covering this case, just because I had a very negative experience this summer. So I didn't want to touch this one. But for my supporters and subscribers that stuck it out with me and did watch the trial with me, I thought it was important to bring you guys this document and go from there. But thank you so much, Senator. Shout out to D with the 2, says back to crooked Canton, not for long, man. Take me back to the South. Let's go back to the South. Let's go back to Florida. Okay. I am out. I am all done up here. Thank you so much, D. Hits me with a 5, says, do these people realize how corrupt they come across at the criminal trial? These people bring the Albert and McCabe clans. Yeah. I mean, we, I've done a lot of supercuts on this channel where we just take all that trial footage and you put it next to each other and you could see it. I think I did one a month ago. I'm actually going to link it to this video for anybody that's new here watching. I'll put a card and we'll put it in the description box. But I took all of their testimonies side by side and we analyzed it, right? So please check out that video if you haven't already. It was one, I think I edited that one myself. So that one was pretty fun to do. But thank you, Dee. Shout out to Lee. Lee is across the pond with the 10. Says, AV, I wasn't able to on Sunday evening, but this is for turning up with the good Sunday evening. Your live and Chatterhood properly cheered up my Sunday evening. Yeah, that's right, guys. We did a crazy case on Sunday. So there was this woman down in Tennessee. She had been tried. I think they were calling it like the lover trial. I was like, no, we're calling it the I'm a PhD. We're calling it the I'm a PhD trial. This woman was dating a married pastor, shot and killed him and injured his wife. And it was a wild story. So if you have not seen that stream, please check it out. But we just did that 2 days ago on Sunday. So that was a lot of fun. It was really great catching up with everybody. I'm glad you enjoyed it, Lee. But thank you so much. And then coming to Cash App, I think I have one. This one comes from E. Capone. I thought I saw it. Where'd it go? I don't know where it is, but thank you so much, E. Capone, for the $7 Cash App. I really appreciate that. All right. That's it. That's all I have, chat. I can't even talk. I need to go relax. It was good seeing you guys. We will be back for Power Hour on Thursday for more Courtney Clenny shenanigans. And then I am arranging a few interviews with Alicia's lawyer. So we're getting that ready for sentencing day on December 8th. And then I am still working with Brian Steele's people to get him on here as well. So lots going on. This was an interesting document. For those that are watching on replay, you know me, I will chapter it up for you. So if you want to go through the different sections or watch them on replay, you'll be able to quickly navigate through all of this. I will see you guys on Thursday. Stay safe out there. See you in the next one. Bye.